Hi guys, it's Kathy. I hope you're doing well. I made it. I had a lot of issues, but I made it. We're doing Michael McDonald. I have I have a close friend, Michael McDowell, and this is just too close for comfort. I'm gonna have to show him this. He's gonna have to change his name. And of course, typing in Michael McDonald, I type Donald. So, Donald, this is all your fault. I know Donald's not here yet. She's leaving, so I have to push this up now. Hi, guys. I'm not streaming on Facebook. That broke. I didn't even try to fix it. I didn't even waste the time. So, I'll fix that some other time. We're going to get this from our Nevada judges. And I have the link to them in the description. And this is the playlist for them. And I picked our Nevada judges instead of some other places because I hear that other places just cherry pick some videos from this. And I'm hoping this is the whole list. Wow. Fozzie. Awesome. But it also looks like there's some filler videos in here. Like this first one is only 3 minutes. This one's 4 minutes. This one's 2 minutes. So I'm wondering if these are all filler and this is where it starts. I don't know. Well, this says part 1. This says part 0. But I do know that our Nevada judges are professionals through and through and through. So these little filler episodes are probably super, super, super informative. They just won't be crazy. But we'll see. We'll see. We're going to press play and get to it.
Alex here with another event on The State versus Michael McDonald. But first, a recap. We did originally intend to appear at the July 8th, 2019 proceedings. However, we didn't get a response from the court on time with respect to our media request. That is most likely because of the 4th of July weekend. Ultimately, defense attorney Craig Mueller didn't make an appearance at that hearing, and it caused the matter to be continued to today. We were present today. We did provide live footage to the public, and the proceedings concluded with another date, this time apparently an evidentiary hearing on the matter, set for July 22nd, 2019 at 10:30 a.m. We do intend to appear at those proceedings and provide the public with another live stream of those proceedings. If anyone is wondering, you can wait until probably the evening of the day that we hold a live stream to review the high quality production, post-production video footage of the proceedings. In fact, most likely within an hour and a half of this video, you will see the proceedings that were held today in high quality on YouTube. The link will be posted in the Our Nevada Judges Facebook, so keep an eye out for that. And of course, we're looking forward to getting feedback from the public on this issue and any other issues that we cover going forward.
Sure.
I'm gonna. You can
And
go
Your
out.
Honor, I have a calendar call in front of Judge Hepburn, so I can't really see it too much.
Well, we're not gonna wait very long. You can go outside and call him. If he's not here in 5 minutes, I'm gonna sanction him.
Yes, sir, I'll
All
call
right,
him.
go outside. Take 5 minutes.
Going back, Mr. Michael McDonald.
335-284, Mr. McDonald, with the defendant present out of custody. Mr. Mueller, why are you late yet again?
I was on vacation when the state filed the motion, and then you set a court hearing on a date I was scheduled for trial on Thursday back from vacation, and I'm actually missing another trial today down in Henderson to be here today. Now, in
You
last
started your trial at 9 a.m.?
10 o'clock, yeah, I'm going to be missing a DUI trial down in Henderson. Now, the reality is that the courts have changed very dramatically in the last few months, and
That's
I'm
true.
doing my very best to adjust procedures. Now, I've spent almost my entire practice for the first time ever in district court, which takes a lot more planning and scheduling. Justice court has been removed from the calendar. Justice court is almost basically doesn't exist anymore. So I've hired new staff, I've put new procedures in place, but we're having a hell of a time trying to adjust all the changes you guys are doing last.
Well, that may be true, but that's only an excuse, and you need to be here. The court can't sit and wait every time on your cases, and quite frankly, it's consistently with you.
Yes, sir, you're absolutely right. I don't even disagree with
So
you. You've
get
changed,
things together, otherwise you're gonna be sanctioned.
sir. If you can figure out how to be in 54 courtrooms at exactly 9 o'clock, please answer for me.
Then
Because I'm in the
maybe you
process-
have too many cases,
No,
that's
I'm actually
not
in the
my
process.
problem, counsel.
I'm in the process of getting out of criminal law, so you win, okay? I've got to please close out the
I
case.
think you've been both effective and good here.
Yes, sir, but the
in
answer
front of me,
is,
but
Yes.
if you have too much, then
you change,
we're constantly waiting on you.
Yeah.
And that's not fair to anybody.
the docket
State,
went from 10 and 12 pages of calendar, so I could guarantee that I could come in an hour and a half later and there'd be no problem, to 5 cases per calendar. You're right, I can't adjust that fast.
Then speak to the Supreme Court.
All right, anyhow, I'm ready to
All right.
argue.
Thank
You're
you.
right, Judge, I'm frustrated, and it's not with you, but the system has changed very dramatically.
Don't disagree with you, state.
And Your Honor, the state requests that you remand the defendant in this case. He's violated the conditions of his release. When Your Honor released him to the medium-level electronic monitoring, you were very clear that he was to have no contact with his ex-wife, Candace Ruiz. He's familiar with that being a requirement in family court as well as his municipal court cases involving her. He knows that he's not supposed to be in contact with her. He mailed packages to her home. It doesn't make any difference the fact that they were addressed to the children. He was not supposed to be making any contact with her. Additionally, since I filed my motion, I've been informed that the defendant has also contacted Candace Ruiz via the internet by leaving comments on a GoFundMe page that she had, which included making references to 1488, which is my understanding is that's a white supremacist statement. Additionally, the defendant was interviewed by Mr. Sanson from Veterans in Politics International. That interview was placed on YouTube. I watched it. In that interview, the defendant admits to having wiretapped Candace Ruiz's phone. There's also history of a GPS monitoring item being found on Candace Ruiz's vehicle that was related to the family court case. That's why I attached some of those documents as exhibits to my motion. In addition, the defendant did a Facebook Live interview in which he acknowledged that he did mail these items to the children, which is a violation of the no contact order. He's not following these conditions.
Number
He should
one.
be remanded.
Thank you. Number one, I believe my colleague has underscored what I've asserted here is the case. This is the state taking partisan sides in the divorce, nothing more. Mr. McDonald mailed, apparently, assuming everything she says is correct, mailed gifts to a couple of kids he hasn't seen in going on 3 or 4 years now. Now, that's not a violation of the no contact order of any sort. Now, my colleague apparently seems to be offended by his exercising his First Amendment rights. Now, there has been no contact.
No. This is the criminal case, not the one we were supposed to. I think I'm just gonna. Oh, I don't want to do this. Hold on. I think. Is this the correct case right here? This right here.
This is a matter of McDonald versus McDonald, D155189.
The biggest problem with this is it's not on a playlist. That I can see. See, these are their playlists. So this is it, but it's not the only one. 12 years ago, I have to go forward 6 years. Or I have to go backwards 6 years. I didn't watch the McDonald case. So I didn't know that that was the criminal. I had no idea. I don't know anything about it. No, whoa, we found it. Okay. So, here's where it starts. It looks like it's 6 videos long. Does that make sense to anybody that has watched this? Okay. Yes, you're right. They have a couple. They have the brother, John McDonald. There's another John McDonald. That's not it. That's his brother. State of Nevada versus Michael McDonald. I think what we're looking for is McDonald versus McDonald, right? State of. This is all the criminal trial. Michael McDonald versus the warden. Oh my God. Okay, from now on, new rule. If you want me to play a trial, you have to send me the link. Back, I'm looking, but I don't see. Further back where? Here? John McDonald. Is this it? No. Way back where? What tab? What do you mean way back? Rebecca's saying wait. This is a JM. She's saying wait again. Okay, but where? You guys keep saying this, but where? In here? In Veterans in Politics and our Nevada Judges? I did have it sorted out. I had it ready. What I was just showing you. I just didn't know. Oh, got it. Rebecca found it. Alright, go away. Alright, save. Unsave this. Well, I'll leave the other one saved because we might
McDonald versus McDonald.
we might want to do the criminal list. From January 7th. I just saw that. All right, here we go.
McDonald D15518905D and T16170957T. The parties are present. Counsel, your appearances for the record.
Russell Collins on behalf of plaintiff, who is present.
George McLaris, bar number 9855, on behalf of defendant who is present as well.
All right.
Mr. Collins, may I have your bar number?
11363.
Thank you.
All right, everybody have a seat. This is Mom's motion to modify the court's temporary orders for custody, visitation, and child support. Mom's also asking for an order to sell the marital home. Dad asked me to deny Mom's motion in its entirety. We have an evidentiary hearing set for June 28th at 1:30. Looks like Mom applied for TPO on 4/18. However, the court determined that a hearing was necessary and set the hearing with me for today. Is that all correct, counsel?
That is correct, Your Honor.
All right, I guess what I am most concerned about, and let me just ask you this at the beginning. Counsel, you were both here for the last hearing,
Correct, Your Honor.
Correct.
and I voiced some of my concerns at that time. I think I was clear about those and that counsel understood those. I'm concerned that Dad gained access to Mom's car on Valentine's Day without her permission and left gifts inside of the car. Counsel?
That's not correct, Your Honor. Essentially what my client did is upon returning the child, what he did is he did put that card in the child's backpack along with a box of chocolates.
Okay.
What we indicated as far as what...
Would I understand, like, you alleged in the paperwork that is a gift from the kids and he was just helping the kids, and I know the kids are young, and I get that. So he didn't gain access to the car and break into the car and leave those there for her?
Did not, Your Honor. No, absolutely not.
All right, counsel,
Your Honor,
were they in the backpack? Were they not in the backpack?
they were not in the backpack. It was left in the car at
Mom's
Madison
work?
School.
Okay.
And there's been other instances, and we don't know for sure if it was Michael that got in. There's been times where she's gone out to her car after school. The windows have been rolled down. The seat has been pushed back. The only other person that has access to the car, that has a key to the car, is defendant.
Counsel, does your client have a key to the car?
Do you have a key to the car?
Yes, Your Honor.
All right. within 24 hours of this moment, those keys will be returned to council. Okay? Council, we will return those to council.
We are trying to get the vehicle too, so I don't know if it's
My client would like me to indicate to the court that the parties are in a discussion to anyway where there's going to be a buyout concerning the vehicle.
That's all wonderful and great. I'm happy for them to have discussion. But for right now, to eliminate this argument, to eliminate the court's concerns, all right? I told you before I'm concerned about this type of behavior, okay? You should want to say, absolutely, I don't want the keys. Let me give them to my lawyer. The fact that you don't want to give them to your lawyer makes me think there's something else going on, all right? Why do you want keys to her car? If you trade cars later, she'll give the keys back and you'll get the keys with the car, okay? You don't have to hold on to them like they're the only keys to the car, okay? You don't need keys to her car. I'm really worried about this type of behavior. It's unsafe. It's controlling. These are consistent allegations. I'm concerned. I told you this before. I don't want to hear this again, okay? Keys to counsel in 24 hours. And then I trust counsel to do with, well, access the car. All right. Okay. That's what concerns me the most. I've issued a stay away order in this case, have I not, previously?
No, I don't believe so, Your Honor. I think the court, the TPO had dissolved. It wasn't my understanding, actually, that...
It was set for hearing today?
That was not my understanding.
Okay.
So,
Counsel?
No,
That's your hearing as well?
you're, I don't believe you issued the stay away order.
Previously?
Previous temporary protective order, and you just implemented that protective order and kept that going.
Okay.
I believe that resolved, or
That
in
dissolved.
February.
Okay.
But Candace did file for a new protective order.
All right.
and Your Honor,
That's
if
what was
I'm sorry to interrupt, Mr. Collins, we both concede that since the last time we've been in court, the parties amongst themselves
Seems like they've been talking a
they've
lot.
been talking a lot. So that's why I don't think this TPO is going to be an issue. I mean, in terms of any kind of a stay away.
Counsel, do you want, listen, what, I can issue a mutual stay away order that excludes times where that allows the parties to continue to talk, okay, via telephone or text or email, but does not allow the parties, excluding visitation, drop-offs and pickups, to be at each other's homes or at each other's places of employment. If either one of them violates it, I'll put them in jail for 25 days. Is that a level of protection that the parties would agree to at this point? It still allows them to talk, okay? And it still allows them to exchange the children, but mom shouldn't be hanging in front of dad's office on a Monday afternoon for no reason.
Your Honor, and that's...
That okay?
I think that would be fine. I think
Counsel, would you stipulate to that?
The caveat to that, Your Honor, is that our position is that she is essentially making these things up since the last time we've been in court. There hasn't been any issues.
If she's making it up, you should want to stay away from the crazy lying lady. Right? And you shouldn't want to be around her if she's making it all up. You should say, absolutely. Let me stay away from her.
We do have that same kind of situation, Judge, in TPO cases where, well, hey, if you want to stay away, then you need to stay away. But
Look,
there has to be
this
sufficient proof for...
I'm asking you if you want to stipulate to it. It's not going to be on his record. It's not like a TPO where you lose access to certain privileges. It's an order of this court that's temporary. It's my order that I could hold you in contempt for, just like any other order that I make. If you want to agree to it, I'm happy for you to agree to it. If you don't want to, okay.
She gets sick and she tries to set up something. That's one of the reasons.
Your Honor, I don't have authorization to stipulate at this time.
Okay. All right. Okay. I am, as to the change in visitation, counsel, why do you want the change in visitation? You say dad can't take care of the kids?
Your Honor, it's been a pretty consistent problem throughout this. I know we've addressed it before, but it's getting even worse.
Well, she already has primary.
The kids are. She does have primary.
So how much less does you want to give him?
Even if we just do a couple hours during the week, I know we had that before where he has a couple hours during the week and maybe Friday over to Saturday instead of 3 consecutive days. The problem is the kids are consistently coming home to Candace late at night on Sunday night. 8
Sunday,
o'clock.
It's supposed to be 6 p.m. on
It's supposed to
Sunday.
be 6 p.m.
So why would it be 8 o'clock?
Because he's late.
Okay, it can't be that late. Can't happen.
Your Honor, it's only been on 2 occasions.
2 hours late?
2
Why
hours
would that
late.
happen?
One occasion was where his grandfather had gotten out of surgery. It was a family dinner that just ran a little bit late. The other occasion was
Another family dinner.
Family dinner.
Another family dinner.
Okay, that doesn't work. Family dinners can't run 2 hours late. Sorry, done. The end.
The point I'm trying to make, Your Honor, and it hasn't been a consistent basis. It's 2 occasions over the past 5
I know, but it's not 5 minutes late. If it was 5 minutes late, 15 minutes late, traffic was bad, the kids wouldn't put their shoes on and get in the car, I get it. 2 hours late, that's in your control. That's on you. That's not late. That's disrespect of the court's dang orders, all right?
I texted another.
There's been more than 2 times, Your Honor. There's been times where he's asked for additional time. Candace has given it to him in the morning when he was supposed to drop him off at 8 in the morning. He texts 2 minutes before he's supposed to be there saying it's going to be 9:30.
All right, look, these are all issues for the evidentiary hearing that is just around the corner, and I'm going to hear it then. And let me tell you something. 2 hours late, don't fly with me. It doesn't work with me. Family dinner, not a great excuse. You're an adult, behave like one. If you're going to ask for more time, you better be there, all right? These are all things I'm going to consider and take into consider when setting up your visitation schedule. If you two can't agree to a visitation schedule, guess who's going to make it? Me. Guess who's not going to like it? Both of you guys, all right? Your behavior has to be like parents. You have to behave like adults. You know, 16-year-olds and 17-year-olds, they're 2 hours late for their curfew. Grown men are not 2 hours late. If this was a job, you'd be fired. Got it? 2 hours late doesn't work. You got mom waiting for kids, all right? What do you think when your kids are 2 hours late? All kinds of bad things. I don't care if you texted her or not. It's disrespectful to her, it's disrespectful to the court, and it's just straight out not obeying me. And if I think you can't obey my orders, I'm going to consider that when I make other orders, all right? Do not disrespect me. Got it? If you two could take care of this problem, you would have already taken care of it. The fact that you can't take care of it means you're here and I have to solve it. I'm very frustrated with you two. I need you to behave like adults, all right? This is a case that your lawyer should have been able to resolve for you a long time ago. I will see you for trial in June. I'm denying your request to sell the marital home, all right? I will order at this point, okay? If I need to order at the evidentiary hearing that it be sold, I will do that. If you two stipulate to list it now, you can do that yourselves. I'm not going to do that for you right now because our evidentiary hearing is just a month away, okay? I will hear all of that evidence then, okay? And I will make a determination then. I am not going to dissolve. I am not going to make that type of order right now without the sufficient evidence that I need. I'm not going to change the visitation schedule now with a month to go. But let me say this. I will consider at the evidentiary hearing, and I want to see every time he was late, every time he asked for more time and was late, every 2 hours you were late. I'm going to take that into consideration. It's a big deal to me. That doesn't work for me, okay? I expect more of you. All right, I expect more of both of you. And from this day on, until the evidentiary hearing, you will not be late.
Yes, sir.
Counsel, anything else I can do
Yes,
for you
Your
today?
Honor. We also asked for a modification of the child support order.
Okay.
Previously, at the December hearing, it was set at $200 because defendant was not working at that time.
All right, and he's working now?
He's been working since
I'm certain that I said then that he had a continuing duty, and counsel knows to update his financial disclosure form. Have we filed an updated financial disclosure
He has, Your
form?
Honor. I have received
The 414 one?
Yes, Your Honor. In addition, today, I know there was a concern because he had changed jobs just recently in March.
Okay.
I have given 2 pay stubs for March and April to opposing
Okay,
counsel.
wonderful. Thank you.
It's not too much of a difference. I think it's maybe $100 a month difference. I have
All
a
right,
copy for the
counsel,
court as well.
you filed the updated FDF, and I don't want it now, all in preparation for evidentiary hearing. I'll make the determination as to what child support should be at that time. It will be retroactive to the time you got the job, all right? And we'll work it out then, okay?
Okay, Your Honor.
Anything else?
There's also just the medical insurance, and I'm assuming it's going to be handled at the
Right,
evidentiary
bring
hearing
proof,
as well.
I want proof from HR about what the cost of medical insurance is for the 2 kids, okay? Not just a pay stub, just for the kids, not for mom, dad, just the kids from HR so that we can do the calculation, I can give the deviation at the time of the hearing and that we don't have to wait for that paperwork.
Your Honor, it's my understanding our counter motion is denied too as well, requesting joint physical custody. It's going to be an issue pending trial.
Right, we're so close to evidentiary hearing, I've already made my temporary orders, all right? What, Mom?
I just have major concerns about the medical neglect and them being dirty and, you know, like...
Let me just be real clear. I expect children sometimes get dirty, okay? Hold on. I expect kids to get dirty, okay? That means they had a great day and they played hard. I expect that before they go to bed, children get baths, okay? All right? And if you want to take pictures of it and bring it to me, yesterday I had to order someone to give their children baths more than 2 times a week, okay? I'll make the same order again. That's my baseline, all right? So let's do a better job, okay? Mom, we can't control everything, all right? What you think is clean and what Dad thinks is clean might be 2 different things, all right? So if you would like to leave it to the court as to what is clean and appropriate, you can. That's fine, all right? But now you know it's an issue, deal with it, okay? Bye.
Thank you, Your Honor.
Thank you. Mr. Grimes, I see you again like an ugly penny.
Angel showed up.
I'm just kidding.
The court said he asked if we could recall it.
Absolutely, Mr. Grimes. Not your fault. I appreciate your professionalism and you letting the court know that he showed up. Vespasian may kill you, but that's a different story. I'm sorry.
Mr. Collins?
Okay.
All right, let's go back to Mr. Grimes' matter just briefly.
Okay, that started out great.
We're on the record again for...
Matter of McDonald versus McDonald, D15-518-905D and T16-170957T. The parties are present. Counsel, your appearance for the record.
Russell Collins on behalf of plaintiff who is present.
All right, and so Mr. McDonald, your attorney is not here, Mr. McGlaris. Is that right?
That's correct, Your Honor. I've been trying to reach him. I believe he might be in the hospital or something might have happened to him. Yeah, he's been having back issues lately, so... Yeah, and he's his sole proprietorship. I haven't been able to get a hold of him.
All right, the court attempted to, well, not me, but my staff attempted to contact his office. There was no answer at his office. Counsel, have you been in contact with Mr. McGlaris?
I tried to call him as well while we've been out there, and went right to his voicemail. I talked to him last Thursday.
Oh, you talked to him last Thursday?
Yes.
Okay, just a few days ago. And was it your understanding that he would be here today when you spoke to him on Thursday? I don't want to know the contents of your conversation, but...
There was no indication that there were any issues, or as far as our conversation went, we ended it with, we'll see you on Tuesday, so...
Okay. All right.
I also talked to him, I believe it was last Wednesday, not the week, or Wednesday after last. So.
All right. And Counsel, you said you got his voicemail. Did you talk to him on his office number, or did you have his cell phone number?
I call him, it's a number that comes with his, it's on his email. It's the number I always call, and it seems to reach his cell phone, because I've talked to him when he's been here at the courthouse a couple times.
So it might be forwarded to his cell phone?
Your Honor, he's never not gotten back to me before either, so...
But I think it's straight. Mr. McGlaris is fairly reasonable and has always made appearances in this case and in others. The court's surprised that he's not here. He's not unbundled in this case. I am going to, well, Counsel, what's your request today?
Well, we're prepared and ready to go. I understand that it's difficult without his attorney here present, but where we don't know whether he's going to be back, whether he's not. I just don't want to. I don't want to put this off indefinitely. Where we're ready to go. Candace is ready to just have this resolved. We spent a lot of time and money to get prepared and be here today.
Your Honor, I have all the documents ready, but I would prefer to have my lawyer here so we could do a postponement of the date. I would also ask Your Honor if I could I should be allowed joint custody of my kids. Like, there's no reason for me not to have.
Oh, you need to stop right now, Mr. McDonald, because there's about 100 reasons. So you probably need to stop talking and wait for your lawyer to get here. Okay? What I'm going to do? No, please stop. Please stop. You need to stop talking. Okay? All right? Because these applications for TPOs I'm seeing, I'm very concerned, extremely concerned, gravely concerned. All right? What I'm going to do today is Counsel, I'm concerned that if we go forward today, we are going to create a situation where we just have a motion to reconsider, and I'd have to set aside and redo all of this again, and I don't want to do that for everyone involved, including the court. It just doesn't make sense. So I do want to continue it and do just a brief continuance. I can't imagine Mr. McGlaris, that obviously hasn't contacted our office. If we had any indication of any medical issue, we would have certainly contacted counsel, and counsel, I assume, if you hear from Mr. McGlaris in the next few days, you can jointly contact my office and we'll talk about scheduling issues. Okay. So I'd like to set the evidentiary hearing and trial over just for a brief
Terry. Thank you so much, Terry.
Continuance. I know that the parties, and it sounds like even Mr. McGlaris was prepared to go forward, and so we shouldn't need a very long continuance at all. The court can accommodate you next Wednesday afternoon, the 6th. Does that work for you, Mr. McDonald?
What time, Your Honor?
At 1:30 in the afternoon.
I do have work. Is there any way that we could do it past 4:30 or 4 o'clock, or no?
It will last for a few hours, and so the court can't start at 4:30 or 4 o'clock because we go into the night.
That should be okay. Yeah.
Okay, so 1:30 on the 6th. Counsel, does that work for you?
Yeah, that should be fine, Your Honor.
Okay, we'll see everybody back 1:30 on the 6th. I am going to ask, I'm going to have my staff attempt to leave a message for Mr. McGlaris and counsel. If you hear from him, I want to hear from you both jointly on a conference call before that date, okay? And that's just for scheduling issues. The parties don't need to be part of that conference call. I want to determine if Mr. McGlaris can go on the 6th and what the nature of his absence is. Certainly give him the benefit of the doubt today. All right. I do want to deal with a couple of issues just briefly. I note that there were a few two applications for TPOs that were filed since the last time you were here. You were just here May 18th. Mr. McGlaris was here at that time. Mom applied for a TPO June 3rd, 2016.
Your Honor, may I speak to that, please?
Not yet. And I just want for everybody to see where we're at, and then I'll hear from each of you. The court, the hearing master there, denied the request for a TPO because the DV hearing master felt that it could be addressed at the hearing coming up today. I don't want to move past today without hearing that issue because I'm gravely concerned about the allegations. So I've read the application. What I'm going to do is ask to swear in the plaintiff, her to tell me what happened and the reasons why she's applying for this TPO and the things that have changed since the last time I saw you in May. And then I'm going to swear you in and let you respond, okay? I'm going to tell you from the outset and remind you again, I'm very concerned. In this case, Mr. McDonald, in the times that I've seen you, I've expressed that every time I've seen you. I've expressed that I'm concerned that you're controlling. I'm concerned about your behavior every time. And what I think that I'm seeing is that behavior increase and get more serious. And the court feels as though it might need to step in to resolve that, okay? So let's swear you both in, right? Please raise your right hand.
Do you and each of you solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Everybody can have a seat right where you are. Counsel, I'll let you conduct any direct that you have of your client.
And we're just dealing with the
just with the TP issue. Yes, just those issues raised in her application.
Can Candace, can you just state your name for the record?
Candace McDonald.
You applied for a protective order on June 3rd, correct?
Yes.
What was the reasoning for that protective order?
My son had come home from visitation on Sunday, and at that time he had a little toy that he was playing with, like on the car door of my handle. And I asked him, I was like, hey bud, what are you doing? And he said, I'm tracking you like daddy. And I said, what does that mean? And he said, daddy has a tracker on you. And I was confused because my son is 4. So I asked him to elaborate, and he said that Michael had showed him on a map that he could follow my car, and there were blue dots, and he thought that it was really cool. And he wanted to follow me like daddy follows me. And so I asked him how he felt about that, and he said that he felt scared to tell me the truth because Michael made him promise not to tell. And he also said that if he did tell, that the judge would put him in jail. And I have never talked to him about a judge or any of this divorce case at all because he's small. So I asked him what was a judge and what did he mean by that. And he said the judge.
I'm not saying it didn't happen. I'm just saying that's a big stretch to say a 4-year-old said all that. That's a humongous stretch of my imagination. I fully believe he tracked her car and did all that. But her finding out because her 4-year-old son told her, that I'm not so sure I believe 100%.
Judge in your divorce. And so he proceeded to stay up for the rest of the night and worry that he made the wrong choice by telling me the truth, and was concerned that his dad was going to go to jail. So after I put him to bed, I called my parents because I was very concerned, and I honestly didn't even really know where to look for a GPS device, if that was really true, and also I'm like, maybe he's confused, I don't know. So I Googled a website to see where it could possibly be, and the website said to check in the engine or in what's called an OBD port, which is where you get a smog check. And so I went out to my car and I noticed that there was something plugged into the OBD port. But I don't know much about cars, so I was still like, I don't know, is that a part of my car? I took a picture of it, I sent it to my parents. My stepdad knows a lot about cars, and he even said, I don't know what I'm looking at. They were out of town at the time. So my parents told me to call 311 and ask what I should do. And 311 advised me to take pictures of whatever it was, and they said that I could remove it if I felt threatened, which obviously I did. And so but they said don't remove it unless someone is present, so that you have someone with you. And I'm like, okay. So my stepdad said, you know what, we're going to be home tomorrow, we'll come take a look at it, I know a lot about cars. So they came the next day, and the plug that's plugged into the OBD port has a lot of cords coming out of it, and then there was a part that was up under the skirting of my car. So he popped that off, and when he popped it off, a GPS device fell out. And on the GPS device, there was a piece of electrical tape over the flashing blue or green light that was on it. And we took pictures, and I obviously felt very scared because he's shown up to places, the gym, other places where I haven't told him where I'm at.
I saw the gym. What other places?
Let me see if I can think of one off the top of my head. Well, he when I filed the original protective order, he was saying that he was going to come to my house and calling me saying, I'm across the street from your house at Lone Mountain, I'm going to come over. And I said, I'm not home. And then he replied with, yes, you are. I know you're home. And so then I was like, how does he know I'm home? Unless he's driven by my house or is watching me somehow, how does he know that? So I called the police because I was naturally really afraid that he might do something, especially because he's bipolar and he owns guns. And so I was concerned. I'm still concerned. I'm still afraid that he's watching me. Before this, I had a previous cell phone that he was tracking. I got rid of that cell phone because I knew he was watching me. He would send me texts saying that he knew where I was at or who I was with. He installed cameras in my house. The old house that we owned together, I was feeding my daughter and I looked up in an air vent and I noticed a flashing light. I reached up in there and pulled out a camera. He had cameras on the outside of our house. So ultimately, and this isn't the first time he's tampered with my car either, he pulled a fuse from my car, which he admitted to at the last TPO hearing. And so, and he's been abusive in the past. And so I'm like literally afraid for my life. So I applied and it was denied. I filed a police report and I spoke with the domestic violence advocate and they told me to refile. They were like, the police said there was nothing they could do because the property hasn't been split. So technically, legally, there was nothing that they could do. But Detective Ray told me to refile and he encouraged me to attach pictures and any text messages or anything else that showed that he like stalking behavior. And up until that point, Michael in one day added me on Facebook, on Instagram, on LinkedIn. When I asked him to stop doing that, he continued to text me over the course of the last month, asking me to go out with him, asking if he can see me, asking me if he can talk to me on the phone. Like, no matter how many times I've asked him to leave me alone, he won't. And so he has a theory that I have a boyfriend and he's constantly questioning me about who I'm seeing or what I'm doing or where I'm at. And then with the GPS device, you know, him knowing my every move is just really scary. And I'm afraid that he's going to show up somewhere or do something or hurt me or hurt the kids. And
is your stepdad here today?
Yes.
All right. Sir, will you stand up? Your stepdad? Oh, he's outside. Shall we get him?
Your Honor, can I speak to this, please?
A moment. I'm going to give you an opportunity to speak. Sir, can you come on up here to the witness stand and raise your right hand to be sworn?
Want to raise your right hand, please, sir, before you say?
Oh, I'm sorry.
Do you solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Sir, will you state your name for the record?
My name is Daniel Dixon.
Will you spell that for us?
DANIEL,
And how are you related to the plaintiff?
she's my stepdaughter.
All right, counsel, go ahead. Will you just ask him some questions?
And I'm going to show you a device. Have you ever seen this before?
Yes, I have.
What do you recognize this to be?
It's a tracking device.
Okay. Do you know where this device came from?
It came from Kansas car.
Okay. Did you help Candace investigate to find the tracking device? And what did you do to help Candace?
Candace was kind of asking me to kind of look underneath the front end of the car and stuff like that to see if I could see anything there. And when I did, I got underneath the steering wheel column, and there's a place where you plug in for your smog device, and that was plugged into it, and then the cable went up and underneath a skirting that was right there by the pedals, and the square piece was laying up on top of there.
Let me ask you this. That was in the interior of the car?
Yes.
All right, so it wasn't under the hood. It was actually...
Inside the driver's side compartment.
Thank you.
Do you remember when that was?
When I found it?
Yeah.
3-4 weeks ago? About that, 3-4 weeks ago?
Do you remember when Candace notified you that she believed there was some kind of device in her car?
She called us. We were in Phoenix, and she had called us and told us that she was trying to figure this out because of what our grandson had said to her, and so she was trying to diligently find this thing. And we got on the computer from there, going back and forth. And
in my head, this dent in the wall right here happened because a witness got really mad and punched the wall. What do you think?
trying to figured out that that would be a proper location for it. And when I got there, it was there. It was plugged in.
Are you fairly familiar with cars?
Yes.
Had you ever been inside Candace's car or looked inside Candace's car before this time?
Many times.
For what reason?
Same reason. She, early on, and when they first got separated,
It's gone. Look, it's gone.
she felt she was being tracked. And we finally discovered that it was her phone, but we were looking in the car and stuff, trying to figure out if there was some type of tracking device in it. But she had some type of tracking device put on her phone.
And when you were looking in, when would that have been, roughly?
That would have been probably last summer, probably also right around November, December again. A couple times we were trying to figure out, things just weren't adding up, so we're trying to figure out what was going on.
And when you were looking in her car at that point, did you see this device in there at that point?
Absolutely not, never.
I don't have any further questions.
Right, thank you. Thank you, Mr. Dixon. I appreciate your testimony. Counsel, do you have anything else to add in reference to the TPO today?
Well, I think there's been a pattern, like Candace has addressed, there's been a pattern of her vehicle being tampered with. And even if Your Honor recalls at the last hearing, when Candace advised the court that somebody had been in her car at school in February, dropped off Valentine's packages and different things, and your court ordered Mr. McDonald to get the key back, which he was very reluctant to do. We don't know if that's because this device was in there, he wanted to get it back before he had to turn over the keys or whatever it may have been. But it's just that the ongoing issues when a TPO has been issued in the past because of tampering with a vehicle, and the activity continues. There's legitimate reason for Candace to be concerned.
Counsel, I read in the application that on the device itself was an indication of the owner of the device, and the owner of the device was the same party who is the defendant's employer.
That is correct. It's his new employer.
Can I see the device? Thank you.
You'll also notice that on the front of that device there's some grayish black tape that covers up what we believe to be a green light that would indicate when the power is on to that device. Also, we believe used to conceal that it was even in there.
Thank you, counsel. Mr. McDonald, is there anything you would like to add? I'll remind you that you're still under oath, but you can remain seated.
Your Honor, may I speak? So first of all, I have never told my son anything about a tracking device, nor have I showed him something on the map saying, "Oh, here, I'm tracking mommy." That is a complete lie and falsehood. I have never said that to him. And him trying to say that exact phrase as a 4 or 5 year old that he just turned 5 is a complete lie. Like, there's no reason for it. As for the tracking device, I have always had tracking devices on both my vehicles. I work at a telematics company. I have always had tracking devices on both my vehicles. I've also been part of testing him, part of our Canadian group for testing the devices. So and she was aware of it as well. She's always known there's tracking device. She may have forgotten about it, but I was doing testing back when I worked at Street Telecom, and they were always that Geotab device that I was testing along with other tracking devices. So I've tested that. Another thing for the cameras, I've always had cameras in my house. She was aware of that. She had our neighbor was broken into. The cameras were installed so that we could watch our neighborhood and also inside. Another reason for the tracking devices was our neighbor's SUV was actually stolen. So we just bought this SUV, and I'm like, "Oh, Candace, we need to make sure it doesn't get stolen. So hey, we're gonna make sure that it's tracked and everything." So obviously she didn't remember that the devices were there. And is it illegal to track your own vehicles? No, that is also my SUV, and it was very concerning when she almost took the SUV and almost ran off a cliff. There's damage to SUV after a night of partying up in Mount Charleston with her friend that's actually here, I believe. There's just a lot, Your Honor. It's been a very emotional thing. It's been a year. There's so much to it. I'm an awesome dad. I love my kids. There's no reason for me not to be able to see them. And she knows that. She's also been getting these TPOs to bolster her claim for primary custody.
What we're talking about today is the TPO only. Okay. So from what you're told me is that you placed the tracking device on the car.
Your Honor, there's always been tracking devices on there.
And you placed them on that car?
Yes, Your Honor.
Okay.
And there is also actually have paperwork from my employer stating that we are required to have those tracking devices in our vehicles. So,
I'd love to see it.
sure.
Your Honor, I've never seen this document.
I am, in fact, a very awesome dad. This is true. I am. Thor, are you still here? I'm trying to remember. A long time ago you said, but my real name is... Did you say your name was Judy? Thor?
Here I copied it from company thing in the chart. Okay. So it's on the second. It starts on the second page here. Okay. Do it right here.
Hi, Judy.
And then there's a picture of.
I think right now they're just interested in that particular document.
There's a picture of the tracking device in my vehicle as well as the damage to the SUV.
I just couldn't remember and I wanted to make sure.
Yes, Your Honor, I also have journals stating the mental condition of her and things. It's really concerning my kids.
Right now, just let him read it. Take it one second time. Start from the start.
I only tracked one of my kids, my oldest daughter. But she knew. It was Life 360 or whatever. Sorry, puppy. My bad. Nancy, this is from 2016. Oh, I don't know how old the kid is. No idea.
Is it against the law to track your own vehicles?
Anything else you want to tell me
There's a lot to this, Your Honor.
regarding the TPO today?
TPO, Your Honor, it's baseless. I've never threatened her. I've never said anything concerning or anything threatening. She's only used this against me to try to get primary custody of the kids because she doesn't have anything else to use. So we have had a period even up to March where we were getting back together. I'd go to her house. She'd come to my house. We were working amicably for the kids. We'd call the kids every night. I was able to talk to them. So, and I would do the same for her. We've been working out everything. Everything's been fine, and she's been trying to deny me my parental rights to my kids. And just to use these TPOs is crazy. It's like there's no reason for it. I've never been abusive. She was in fact the abusive one. She was hitting me and punching me. I've never hit her, Your Honor. I've never done anything. I've had to restrain her a few times. I admit that. But I've not done anything that warrants a TPO or trying to take my kids away from me. I love my kids. I've never been abusive.
Only 2 of my exes so far have found out that I'm tracking them, but they didn't take me to court for it.
I'm a nice and honorable guy. I would never do anything like that. And so for her to use this TPO in the court to try to say, oh, you can't, now I'm going to take your kids, and so that she'd get money, it's completely baseless. So I'm asking Your Honor, like just please disregard this, and this is something that should not be used against somebody, because and she also knows the law as well, as she used to work as a divorce lawyer, Shapiro Group, when she was in college. So I also have text messages threatening, hey, I'm going to get a TPO against you or I'm going to get a restraining order against you if you don't do this, or if you don't give me my money. So it's like it's just a case of money. It's like it's retarded. We need to work what's in the best interest of the kids and try to be good parents for them, full parents.
Watch it,
and that's
buddy.
it. There's no other reason for us causing conflict in any little thing that could be used. So. And then trying to say, oh, you've done this and that, and there's a lot, Your Honor. I have pictures and documents, especially to her mental state and capacity of wanting to kill herself, using drugs. Like, it was very concerning. As for the first TPO that was put in place and disabling the vehicle, she almost crashed the vehicle. If you look at the document of the damage to it, she ran off the road, almost running into the ravine. Luckily, a pole stopped her from hitting it off there. She could have died, like, from partying and drinking that night, like. And that's when we were separated. So, I made a mistake. I shouldn't have disabled the vehicle. I was very concerned about the kids' sake, and for her after reading these journal entries of, oh, I'm going to run away. I want to kill myself. I don't want to live anymore. And I have proof of this too, Your Honor. Like, and it was never even heard in the first TPO hearing of her doing drugs and everything else. I have proof of that as well in journal entries. That I was going while we were separated. I would go to the house and watch the kids. She would go on dates and stuff, and it was very emotional, Your Honor. And it was over a year ago. I mean, this was I made a mistake by doing that, and that's the only thing she could use against me. Hey, I'm going to get a police report. I was in a very emotional state for her cheating on me and finding out that she loves this bipolar guy that has no car and job. And I have proof of that as well.
This is all stuff that's been hashed out before.
Well, and I've explained to both of these parties before, you're getting a divorce one way or the other.
I understand that.
Nevada is a no-fault state. I don't care who was a bad husband and who was a bad wife and who said what and blah. It's not my business, all right? My business is creating a plan for your family to move forward, all right?
That's all I want.
So,
that's all I want. So my kids.
You're getting a divorce, okay? I don't care who she's seeing or who she's dating, or I expect it's taking an emotional toll on you. That's what happens. You don't have to tell me that, okay? I have a couple of questions for you. I want you to answer them.
Yes, Your
You
Honor.
indicated that you've disabled the vehicle in the past. You indicated that you placed a tracking device on the car previously. Have you been actively tracking her since the two of you have separated?
No, Your Honor. I haven't tracked her, nor have I have better things to do with my time than
Okay,
track.
so you have not utilized the tracking system through GeoTab. You have not accessed that software since the time that you two separated.
Since the time that we separated. Can you reframe the question? Like
Okay.
Like since what? Since we've been apart? Have I not?
Yes.
Like I said, I'm the IT guy for the company.
Have
so
you accessed the software and tracked her?
It's being tracked automatically. Your Honor.
Have you seen it? Have you looked at it? Have you gone on?
We do reviews of it sometimes. Yes.
Okay. So you've looked to see where she's been?
There's been occasions I track my own vehicle. That's part of the.
So kind of a yes or no. Yes, I have looked at where she has been, or no, I haven't looked at where she's been.
Your Honor, I've tracked my own vehicle. Yes.
You track her in that vehicle?
That is my vehicle as well. Like, I've had tracking devices on both vehicles in which I track.
I'm not so concerned about your vehicle and tracking yourself. You can do that all day long. My question is about her and the vehicle she's driving, pursuant to my order.
So I will admit to this. So there, around midnight, I even have my friend was over. my guy friend is my best friend. And my dog starts barking like crazy. It's around midnight. He's about to leave. He's like, what the heck's going on? So we look out the window, and we see this car going off. And that's when, this is when she found the tracking, she remembered that there's a tracking device. She said, why was there a car outside your house? And I'm like, Candace, do you have a girlfriend over? I'm like, no, I don't have a girlfriend over. I have a friend over. Would you know that, too? How would you know? And was that you when the dog was barking? I saw a car going out. I looked out my window. And that, in that case, I did ask that, and my friend can attest to that as well. Like, he was there, and that after that, she's like, oh, maybe there's a tracking device in my car, if I remember. And she brought that up to me in conversation over the phone, like, there was a car in front of your house around midnight. What's she doing driving past my house at midnight? Like,
Are there any other instances where you logged on to see where her car was, other than that one?
there was a few other occurrences of both vehicles. It'd take a lot to explain, but I don't do the software side. I do the hardware piece of everything of the company. So I'm not as familiar with everything, but yes, it can be tracked. It is, whenever the device is plugged in, it tracks the location of the vehicle.
I understand that. I'm asking you whether you got on the computer, your iPhone, or whatever it is, and access the information.
Have I ever did none? Yes.
Since the separation.
Both of it, yes.
Okay. She indicated that you sent her some concerning text messages.
Nothing threatening. That was the time when we were trying to get back together. I actually went over her house and spent the night and it's not true. And I have text messages for that as well. So she invited me over multiple times. This was actually recent too. This was back in February, March. So yeah, and then after the thing blew up, and I have other text messages I can show to you as well. So it's been an emotional thing. Sure. So.
Anything else you want to tell me?
Like I said, these TPOs, she's been using them and threatening them the whole time. There's nothing in me that wants to track her, cause harm to her. She's the mother of my children. I just want what's best for my kids, and what's best for them is for us to co-parent and be good parents to them. I don't want anything. If she wants to go with all these crazy guys that she's been doing, even guys that have contacted me, which has been crazy, it's just there's no reason for it. There's no reason. I'm done with that. I don't need to be with somebody that's going to do that. I wish her the best on that, and I just hope that we can be friends and good co-parents for our kids. That's it. But that's going to take a while to do. So that's all I need to say. Like, there's no other reason for these TPOs, and I have not been doing anything that warrants it. So.
Counsel, briefly.
Yeah, there's a lot in there, but the main issues I want to touch on is the tracking device. The email that it was been provided today, it's dated this month, and it does say that employees can use these in their vehicle. Doesn't say anything about their spouse's vehicle, and it should be noted that he didn't start working for this company until March. And so if that's this company's policy that was in place in March, then that tracking device had to have been put in sometime after March. And I don't see any reason why, based on what I read in that email, why he can't do exactly what he needs to for his company, tracking his own vehicle, which is apparently what they want to do to test this software.
We decided to up the crazy Karen a notch. It's a male Karen this time, and it's crazy.
A lot of allegations about Candace doing drugs and partying and driving down the canyon. It was all stuff that was addressed in the initial TPO hearing. That all the allegations were proven to be false, and Candace is not a drug dealer, she's not a drug user, she's not an excessive partier. She takes care of her children and goes and teaches school. That's basically the essence of it. Also, with the tracking device, just one other thing. Candace had the smog down on her car in August of last year, of 2015, and the device was not there. So we're not exactly sure when it got placed, but just the getting back together, that's never been with us. We've produced evidence with our reports, with our motions, that he's tried multiple times to get back together with Candace, and every time her response is no. Leave me alone, quit talking to me, talk to me. If you want to talk to me about the kids. And it just keeps going on and on and on and on. And here we are again addressing the same thing again. It's been over a year where we've been told about all this evidence that's out there, all this evidence about her partying and everything, and not one thing has been produced. And here we are ready for trial, and we haven't received anything.
All right.
Your Honor, can I speak to that as well, please?
Just briefly.
So, first of all, I do have evidence I presented to you in all the court documents. If you could review the journals and the other pictures that I submitted, they weren't looked at. There nothing, the drug use, the mental instability. She was the aggressor in all every instant that we had. She has severe depression. She has PMDD, which is post-periodical dysmorphic disorder, which causes severe mood swings. She also is bipolar. She has a history of punching and hitting and throwing jelly jars while the kids are there yelling in front of them. I'm really concerned for my kids, and they're seeing this. They're coming to me, Daddy, I want to stay with you. I don't want to be with Mommy. Like, Mommy's yelling at me. Mommy's spanking me. Mommy, like, I don't know what to do, Your Honor. Like, I'm very concerned with her. Like, she always be hitting and punching. I don't want her doing that to my kids or in front of the kids. I know that she's been in counseling, and I hope that she's making progress there. And I have journal entries to all this, and I beg if you could look at those and try to determine that. Like, there was no means to which I had to stop the abuse in a lot of ways. And if you read, it's a lot stemmed from her father and the beating her mother right in front of her, and just having all kinds of different issues that just an emotional roller coaster of this
None
matter.
of this is relevant to
All right.
the current video.
Okay. What I'm going to do today, everybody sit down. I'm going to issue a ruling. While I'm talking, nobody else is going to talk. All right? You're going to listen. I'm going to give you the parameters.
You can't
of this
control
ruling.
me.
I'm also going to set a
I can
temporary
talk
order.
anytime I want
It's
to
going to
talk.
be temporary until we come back next week. Okay? I am very, very concerned. All right? Your behavior is not consistent with what you're telling me. Okay? Since the first time I have seen you, and I have seen this case, my response to you has been the same. I'm concerned. Okay? Your behavior is very controlling. It is not stopping. It is getting worse. And that worries me significantly. A 4-year-old just turning 5 doesn't know what a tracker is, shouldn't know all of these things. There's only one reason for them to know about a map and a blue dot and a device on the car. Okay? That concerns me, that you're teaching your son to behave in a way that is controlling, that is disrespectful to his mother, and is contrary to my orders. From today forward, there will be no tracking of any telephone, of any car, her car. Counsel, you'll keep the tracking device in your possession until further order of the court. There'll be no speaking on the telephone between the two of you, no texting. You will utilize talking parents exclusively. We will give you both the pamphlets today. Mom, you have 48 hours to set up the account. The account is free of charge. It will ask you for Dad's email. You'll put Dad's email into it. Dad, you'll get a request and you'll join that account, okay? I'll be privy to all of those communications, and those will be concerning solely your children, okay? And nothing else. You are not allowed to talk about anything other than your children, and that is it. I expect for those conversations to be professional. Professional means you will talk to each other as though you talk to a coworker or your supervisor. There will be no talking about any other subject and no inappropriate comments. Do you understand? That order is until further order of the court. I am today issuing a TPO.
That must have been hard because 2016 was like right in the middle of Game of Thrones. So they couldn't talk to each other about that at all.
In addition to issuing the TPO, I'm issuing a firearms order. Defendant Michael McDonald shall not possess any firearms until further of the order of the court. You have 24 hours to make arrangements. There will be no firearms on your person, in your home. You will not have access to firearms. Do you understand?
Your Honor, I actually go shooting with my buddies all the time. We're in an IT shooting group and stuff, so I ask you not to do that. There's no reason for it. I've never made any threatening.
We're in an IT
The reason
shooting
is,
group.
and let me remind you again, that the court said I'm talking now, and that nobody will interrupt me. I've heard the evidence regarding the TPO. I have presided in this case for months, seen the increasing behavior that concerns me. I have been concerned about this case for weeks. You keep me up at night, Mr. McDonald. Your behavior is concerning to me.
Why, Your Honor? Why? Can you explain that?
All right, for the last time, do not interrupt me. Your inability to follow my orders concerns me. I am concerned. I cannot express to you how concerned I am about your behavior. Over time, it's increasing. It is controlling. You don't get to know where she is, okay? You don't get to track her car. You don't get to track her phone. You don't get to disable her car, okay? All of those things are very inappropriate. And one of them, taken alone, like the Valentine's Day incident, that taken alone, I can give you the benefit of the doubt. But when I see a pattern of behavior over months, difficult for me to give you the benefit of the doubt. Do you understand? It has to stop. Temporarily, visitation is absolutely suspended. You're to have no contact with the children until further order of this court.
Your Honor,
We will see you next week for a hearing. We'll see you next week for the hearing. There'll be no visitation until then.
Listen.
I am concerned about your behavior. I'm concerned about your access to your children. I'm concerned what information you're giving them and your behavior while they're in your care. I cannot explain to you any more. I have given you my thought process. It is your choice, your chosen course of conduct in this case that has resulted in this order. If, for any reason, counsel, there is anything, any violation of any order I've made today, and counsel, I want this order to be signed within 24 hours. You're walking out with the TPO today. You get me that order this afternoon because I'm going to sign it. Because you're going to have a copy of it in your car at all times, in your house at all times, and at your school at all times. Any violation of this order, I want to know. And I will put it on calendar within 24 hours, and somebody's going to jail. I will put you in jail for 25 times for every violation, okay? It's not sinking in. What I've told you from the outset of this case is simply not sinking in. And I've given you the benefit of the doubt after the benefit of the doubt. You're not learning. You're continuing. Mr. McDonald, my punishment will be harsh and swift. Please understand that I'm very serious. She will be safe, and your children will be safe.
May I speak, Your Honor?
No. I want you to really listen, because I have this distinct impression that every word that I've said since the beginning of this case, you did not listen to. So today you listen. We will see everyone back on Wednesday. Counsel, as soon as I hear from Mr. McGlaris in any fashion, I want to have a phone conference just for scheduling.
He's reaching into his pocket right now to text her.
So we can confirm that we're going forward next Wednesday and confirm his health condition. If it's something that is serious and we need some more time, I want to accommodate
I'm in love.
that. And so let's the three of us discuss that. So if for any reason you have any information about him or someone from his office contacts you, please let me know.
Absolutely.
All right? And I will, my office will contact you if we hear from Mr. McGlaris.
Okay.
All right? Thank you, counsel. I do need that order relatively quickly because I want to sign it very quickly. Thank you so much. Good luck to the parties.
Anything else? There's nothing.
This is the matter of McDonald versus McDonald, D15518-905D and T16170957T. The defendant is present. Counsel, your appearance for the record.
Russell Collins appearing on behalf of the plaintiff who is going to appear telephonically.
Right. Everything has been telephonic today. Do you have a phone number for her, counsel?
I do.
And if you'd like to waive her appearance today, I'm happy to do that as well. So it's up to you.
That's fine. We've got the phone number. She's ready.
Okay, well, let's call. We'll get her on the line then.
Where's his
You
attorney?
two can have a seat.
All right, I know a bunch of you have already seen it, but a bunch of us have not. So just be careful about spoilers, okay? Be careful about spoilers because we want to enjoy this.
Hello, I'm trying to locate Candace. This is Michelle in the court report for Judge Marquis. We're getting ready to go on the record with your case this morning. Thank you.
Ms. McDonald, we're on the record. Mr. McDonald is present in the courtroom along with your counsel.
Okay, I'm here.
Ma'am, I'm going to ask you to either, if you're not able to put the children in another room or have somebody to watch them, I'm not going to allow you to participate via telephone, as we don't routinely allow children in the courtroom. I wouldn't want them to hear any part of what's going on today.
Okay, no problem. I'm stepping out right now.
Thank you. Counsel, this is on today for Mom's motion for an order to show cause and for attorney's fees. I've reviewed your request for show cause and granted your request for order shortening time. As I indicated previously, I would be inclined to do. So you didn't file an opposition. I understand that was on an order shortening time and that time was short. So today...
Judge, may I speak, please? I have a couple of things.
Okay, one moment. I'm going to finish talking and then I'll give you an opportunity to speak. If you would have an opposition, I'm going to allow you to tell me that opposition now. However, I want you to understand the seriousness and what I expect you to tell me and the consequences of certain things that you're going to tell me, okay? I understand that you don't have counsel right now. And so I'm going to make sure that you understand this, okay? What they're asking for is a show cause hearing. The show cause hearing won't be today if I grant it. It will be sometime in the future, okay? At a show cause hearing, I would make a determination of whether or not you receive a fine from the court, or you go into jail for 25 days, or I don't hold you in contempt of court, okay? So today I don't want to hear from you whether or not you did
With a little more slurping sounds?
what they said you did, okay? Because you don't have an attorney representing you. There'll be another day for that, okay? Today, what I'm looking at and the decision I'm going to be making is narrow, okay? Whether or not they have a sufficient showing for me to set a hearing, okay? Take your hands out of your pockets. So that's all I'm going to look at, all right? They have an email from you with a date on it, okay? And so I'm going to make a determination today if that's sufficient for me to set it for hearing. I don't want you to tell me today, okay, whether or not you sent it or why you sent it or what you thought or what your intentions were. I don't want to know that today, okay? That can incriminate you, all right? What they're alleging you did is also a crime, okay, for which you could be prosecuted by the state of Nevada and sentenced to jail, independent of my jail sentence. So it's very important that I tell you this and explain this to you today. I don't want to hear from you whether or not you sent it, okay? I don't want to hear about what your intentions were or what you feel or any of that. I have a legal standard, whether or not there's sufficient evidence for me to set this for hearing, okay? So if you want to address that, I'm happy for you to address that. I am not going to remind you again, okay, of what I want to hear from you. I'm going to let you speak, okay? Go ahead.
Judge, first off, I'd like to motion for a continuance, 'cause as I received a summons at 4 p.m. at work yesterday, and I talked with some attorneys, Lee Lefty and a couple others, and also seek some counsel from or recommendations from my cousin and uncle Bonaventure and stuff. I could not retain counsel, nor have I received any funds from my previous counsel that has killed himself. So I want to be able to say that first of all. Secondly, Judge, I do want to say that the message is emotional and miss my kids. I recently talked to my pastor and friends, and I realized that it should not have been put in place. My attorney recently committed suicide, and I've lost my counsel. It's been very pressing on me. After finding out the court date was moved in August 16th, and that I might not get to see my kids for over 45 days, it was unclear when I would see them next. I was emotional. In the future, I will only talk to Candace about the kids and not be controlled by emotions. I'll respect whatever you say, Judge, and I would appreciate you giving me as much time with my kids as possible. I love them very much, and I want nothing else but what's best for them. Oh, with that being said, I'd also ask that is there any law saying that she should not bring the kids out of state, like bringing them to California or running, like abducting her kids? So I believe she's taken, from what my friend has told me, but she's president, and if you'd allow him to speak to, he has a good message about how I am as a father and how much I love my kids. But I believe she's taken my kids and ran or moved. I don't know what she's doing. She's also been posting things on Facebook and things about our court case to her almost 700 friends. So I'd like you to take that in consideration. And please, Your Honor, don't. I just want to be able to see my kids. I'm a good dad. I'm very emotional through this process. My parents actually were in your court as well, being you being the judge for them, and you just determining a ruling on that recently. So there's been a lot of issues going in my life, and especially with my attorney going through this. I just ask that you please take that in consideration, and please just let me see my kids, Your Honor. I love them and do what's best for them, and leave emotions out of this. Thank you.
Counsel?
Your Honor, there's been a lot of allegations, innuendo, in this particular email that was sent that caused great concern, especially after Your Honor was very clear at the last hearing with what.
So I thought I was extremely clear. I thought I couldn't be more clear. I thought I was just the clearest possible. That was my intention.
And that's what we thought. And to have this happen less than a week after that hearing is very concerning. And some of the stuff that was said in that, and
Specifically, counsel, because this is a long email, please highlight what you're most concerned about.
If you look at
Quick summary. In the last hearing, the judge said absolutely no form of contact whatsoever, except Talking Parent app, only about the children. Other than that, do not say a word, no contact, or I'm putting you in jail. You're going to jail for 25 days. She said, my punishment will be harsh. He sent an email.
I believe it's on page... consequence number 2 in page 6 of 8 of the email.
I will do whatever it takes with appeal court or whatever have you, even bringing it to the Supreme Court and changing the law so that other father will have to experience what I'm going through right now to earn what is rightly mine, joint physical custody of my kids, even if that involves me selling everything or taking drastic steps. Is it the drastic steps, Kearns, concerns you?
And then if you follow on to page 7, the next little paragraph.
I'm even willing to live with friends if I have to, where you end up with nothing after everything is said and done. And no, I'm not
Yeah, I guess Maiko's right. He wanted to send it, so he's fine. He wanted to, guys.
playing.
That is probably the most concerning. He makes several allegations throughout of the kids hating Candace or growing up to despise her. While there isn't a direct threat there, there's an insinuation that he is the one that's going to turn the kids against Candace if she continues down this and keeps fighting for her children's rights and to keep them safe. Those are the most concerning parts of this email for Candace.
Right, counsel, anything else?
I don't believe so, Your Honor. It's just concerning that we're here just less than a week after our last hearing. There have been some other emails that weren't. If you look at the addendum that we filed, there was an email sent that he was going to come to Candace's parents' house and pick up the kids on Friday. And that was another reason we wanted to get this on.
In violation of my order?
Judge, may I speak to that?
And that's
Yes, sir.
as exhibit. It's Exhibit 6 to our
Okay,
addendum.
I see that. All right, anything else, counsel?
Not at this time, Your
Right.
Honor.
Mr. McDonald, do you have a response?
Yes, Judge. It was very unclear after the court date was moved, as we were to reconvene on yesterday on my daughter's birthday. I was trying to see. I sent through talking parents when to verify that I can have a birthday party on the 9th. I didn't get a response to that. I also called your chambers because after they postponed it to August 16th, it seemed like I wouldn't be able to see my kids for 45 days. So I called your chambers and asked, is there an order in place that said that I can't have my kids? Your clerk or whoever the person that answered the phone, I believe it was Lisa, I don't remember the name, she told me that no, there wasn't an order and I should still be able to see my kids.
Yay, Gail.
We don't have anyone that works for us named Lisa. None of my staff would ever tell a litigant something that litigant can read in writing. My minute order
Bye,
says
Walter.
all previous orders shall stand. That means all my custody orders stand
Custody orders from
from the last hearing. Okay?
Okay, because I was under the impression you said I'd be punished for this weekend when I can't see my kids.
All right.
It was very unclear, and I did not have that order.
Bye, love.
All right. I'm going to be real specific today. Everyone that leaves this courtroom today will understand how we're going to move forward, and I will make sure that they understand how we're going to move forward. What else do you want to tell me today?
I really want to ask, is there any law saying that Candace isn't allowed to bring kids out of state? Like, I'm kind of pretty concerned about that, and Facebook and slandering me online and stuff. Like, I don't believe that's right. Like,
Are you requesting me to seal this case?
It absolutely doesn't matter if he's lying or telling the truth. It doesn't matter. Because the words that we heard in that email were not about the kids. Him doing whatever it takes, taking it to the Supreme Court, sound like they're about the kids. They're not about the kids. Talking about the kids is talking about the children, not what he's going to do in court. So he going to jail. I mean, he did it.
Or issue a gag order? Is that your request?
yes, Your Honor, that and possibly in order for her to bring the kids back to Nevada. Like, I don't want her staying out there in California or something away from. I have proof of this too, like of her leaving or whatever. Like,
All right. Let's address.
Your Honor, if I could address that real quick.
Okay.
'Cause that causes even more concern. Candace has gone on vacation with the kids. She's a school teacher here. She's not going to abandon her job and take the kids out of state. She went to visit some family. The fact that defendant knows exactly where Candace is right now is very, very concerning to me because we have never told him And it's concerning that he, after the last incident with the tracking device in her car, the fact that he knows exactly where she is very, very concerning.
Judge, my friend told me about this. He showed me the Facebook thing. I have the printout here, and it was concerning. I didn't know where my kids are at or what they're doing, if they're okay. Like, it's very concerning to me, and just where's my kids? What are they doing? Are they okay? Like, I have to think about this, especially with the actions that Candace has taken and the craziness that she's, or the things that have happened. So, I'd really, if you'd like, I'd like my friend to speak if that's possible.
That's not an issue that's on calendar today. I will give you some guidance as to that issue, but I'm not going to hold a hearing or hear testimony or evidence about it today because it's not on calendar. All right? You both can have a seat. Let me make this very clear. All right? Have a seat. It's unfortunate, the circumstances that surround your legal representation at this point, and the court is certainly concerned about that. Certainly don't want you, Mr. McDonald, to have any negative consequence because you were left without notice, without counsel, okay? The court continued your evidentiary hearing on its own based on the news that your attorney's passing, surprising passing, okay? That is so that you could obtain new counsel or prepare yourself to represent yourself, okay? It would be unfair to you, for you to have to represent yourself or for a lawyer to come in and represent you with just a few days' notice, okay? If that lawyer had asked for a continuance, I would have given them a continuance. And counsel would have certainly allowed them that continuance, okay? So, hold on. What I was doing, and this is the time I really want you to, again, we've talked about this a couple of times. Instead of thinking about what you want to say to me right now, you've had an opportunity to talk to me. Okay, now I'm talking to you and giving you my order and some guidance, all right, to benefit you. I want you to listen to that and not interrupt me, okay? Do you understand that? Okay. So I continued the hearing 30 days to give you sufficient time to find new counsel or prepare to represent yourself, okay? During that time, and my minute order is clear, that my previous orders stand. That means that the order I made eliminating your visitation stands until the hearing date. You can request at that time make-up visitation. But at the last hearing, all of the reasons why I gave you to suspend your visitation temporarily remain. Remember again, now is the time for you to listen. You had a time to talk, okay? I don't want you to interrupt.
Don't interrupt her.
I don't want you to interrupt me. I really want you to understand. To remember that I told you at the last hearing, I'm concerned you are not listening and you are not understanding my orders, okay? You continue to violate them. That's why I think you're not listening, okay? And when you interrupt me, I'm concerned because I don't think you're understanding what I'm telling you, okay? I gave you opportunity to speak, and now I'm telling you my order. I am not going to reconsider this order, okay? This is my order, and then the hearing is over, okay? So now I need you to listen, okay? I suspended your visitation because you admitted to disabling her car. I'm concerned that you placed a tracking device on her car. That while that tracking device was placed on her car, you accessed the tracking information. I am concerned about you placing Valentine's gifts in her car while she is at work, all in violation of my orders. As I have told you, not just at this hearing, but at other hearings, I am concerned by your behavior. Domestic violence and stalking are of great concern to the court. And this type of behavior is not consistent with what you are telling me, okay? So the words you are saying here in court are on one side. Your behavior is the polar opposite, okay? This recent email, in direct violation of the court's order, just days earlier, after I took the time to explain my concerns, to explain my order, you totally disregarded the court's order in such a fashion that there would be wonderful evidence of it. An 8-page email dated and signed by you. So that shows me not only did you absolutely disregard the court's order, that you didn't care if you were caught, because you knew you would be. That concerns me. As I said before, the pattern of this behavior is increasing in its seriousness and its frequency since the beginning of this case. I am gravely concerned about your behavior. This is about the third hearing that I've told you that, and you don't seem to understand that. You cannot have any contact with her other than talking parents, and at talking parents, you may only discuss the children. So let me be very specific and revisit my order. There is a temporary protective order in place. That means you are not to be in the possession of any firearms. Not one, not any kind. You're not to be in a house with firearms, right? You will have no access to firearms while this TPO is pending. You are not to contact her, okay? Via Facebook, Snapchat, email, text message, telephone, smoke signal, third party, in any way. You laugh, but you've already violated it, okay? It's not funny to me. You will not have absolutely any contact with her. Do you understand that? The one and only place and the only method that you may talk to her is through talkingparents.com. That site can be looked at by the court and by counsel. Counsel will certainly print off all of the records of that communication, and he will certainly present them at trial, and I will consider them. Okay? The type of communication that is appropriate on Talking Parents is about two things: Mason and Malia. And that's it. What I don't want to see are emails like the one that counsel brought to my attention. When you talk about the children and the impact of the divorce on the children, that is not appropriate conversation for right now. What is appropriate conversation right now is perhaps Mason isn't feeling well, and I took him to the doctor, and this is what the doctor said, and this is the type of medication prescribed by the doctor. She can tell you that information for right now, okay? Perhaps there's a schooling issue. I know they're young, all right? Perhaps there's an issue at school that the two of you need to discuss, okay? Or a religious issue about the kid's upbringing for right now that you need to discuss. That's imminent, that the decision has to be made right now, okay? Those things are appropriate for discussion right now. It is a business relationship now between you and the plaintiff, all right? You will speak to each other like you speak to coworkers or to a supervisor, all right? This type of 8-page email discussing consequences and that, the court's very concerned about you will end up with nothing, I'm not playing, taking drastic steps. That's very concerning to me, all right? Very concerning to me, okay? I've expressed to you my concerns. All you are doing is proving them to be correct by this sort of email, in direct violation. You were here in front of me just days prior, and I thought I couldn't be any clearer about what I expected from behavior from you, and I was wrong. No contact, not 100 yards to her place of employment. I don't want you 100 yards from the kid's school. I don't want.
What about his friends stalking her instead?
you 100 yards from her residence. Do you understand? I specifically said you're not allowed to track her via tracking device. Okay?
She said he was going to jail if he broke this order.
I am concerned, Mr. McDonald. Okay? Very concerned. That is why, on a temporary basis, I suspended your visitation. Because you cannot comply with court orders. You've shown me over and over that you cannot. This is the 6th application for temporary protective order in the history of this case. That's concerning to me. I must protect your children in the only way that I can. What you tell me in the courtroom and the words that you say are not consistent with your behavior. To me, behavior speaks much louder than words. I need your behavior to be consistent with your words. If you show me you can comply with the court orders, okay, that you can do what you're supposed to do, that you can communicate in the way that the court orders, the outcome could be much different than the temporary order. I have given you the opportunity time and time again to do that. My concerns regarding this case get greater and greater as time goes by based on your choices. Your choices. Your chosen course of action. Okay? I need for you to obey the court orders. I am granting the plaintiff's request for order to show cause. I'm setting the show cause date at the same time as the evidentiary hearing. I am going to, counsel, I'll need you to prepare the order to show cause. Attached to the back of that, a jurisdictional affidavit outlining the specific order and the allegations of wrongdoing. In addition, I am...
So it sounds like we don't know if he's going to jail for this yet. She's doing another hearing. She just found probable cause. So we'll see.
I'm going to set a status check date for 1 week before the 18th, okay? At that 1 week date, I will, it's for confirmation of counsel. So if defendant has counsel, I'd ask them to appear on that date to confirm that they'll be stepping in on this case. If the defendant does not have counsel on the 18th, I may, pursuant to recent Supreme Court rules, appoint him counsel for the sole purpose and the order to show cause, okay, hearing. That person would represent you just in the show cause hearing, okay, not in the other hearings and everything else we have on calendar. Do you understand that? So they would represent you only on that issue. All right? They would not represent you on any other issue on that date. Okay? However, if you have counsel and you've hired a new attorney, they may represent you on everything. That's why I'm going to set that date on the 18th. Let's set it at 8:45 on August 18th. Any other questions? Oh, I'm sorry. Your date is August 16th. Excuse me. So let's set it for the 9th at 8:45.
Judge, may I speak to...
Certainly.
Judge, last year around this time, I was unable to bring my kids on a family fishing trip up to Duck Creek. We plan this every year, and when we bring our kids up there, their cousins and everything, we teach them how to fish and have a good time. I really need that time with my son this year to bond with him and to be there and to teach him how to fish. And it really changed my life going up there and being with family and friends and just having that community and being able to teach and being among nature. So I really feel like it's really important for my son to be in the office. And talk to Candace about that as well. And I feel like she feels that way as well, but I don't know how she's feeling at the moment. But it's very important to me. It's also important to me to know what's going on with my kids and if they're okay, what they're doing. Like I'm their dad. I want to be present in their life as much as possible. And I really feel that it is not best for my kids not to be able to see me. When they're with me, I'm all about them. They're my kids. I take care of them. I don't put them in front of the iPad or or let them watch
That's
us.
when we're watching and tracking mommy's car.
Your Honor, I have never done that. I promise you, I would never do that to you.
We'll hear more about that at the evidentiary hearing, but those are my concerns.
I have never
Remember
done
at the last hearing, I was very concerned that you showed Mason the blue dot on the screen.
There isn't
Hold
a
on.
blue dot, Your Honor.
And that
Okay.
you wanted to track, and he wanted to track mommy's movements just like daddy did.
There's no way.
That is very concerning to me.
It would be to me as
It is
well.
one of the reasons I temporarily suspended your visitation. That order will stand.
Your Honor, would it make sense for me to tell?
At the evidence.
I wouldn't do that. I wouldn't. My son.
Many of the things that you've done in this case don't make sense to me, Mr. McDonald. When I hear all of the evidence at the evidentiary hearing, perhaps I am totally wrong. And at that point, I would grant you make-up visitation. But that's your burden to show me, okay?
45 days of not being able to see my children.
My temporary order will stand. I'm not going to allow them to go out of state with you or Mason to go out of state on the 6th based on the issues that are present in this case.
It's been 2 years. This will be the second year that I'm not able to take my kid.
I understand your concerns, and it sounds like a wonderful trip, and that Mason would benefit from that. All right, and we'll make that determination when we come back for the evidentiary hearing. All right, I will see everybody on the 16th, and on the what date did we set for?
August 9th at 8:45.
August 9th at 8:45 for confirmation of counsel. All right?
Is there any way that I can see my kids before?
No. Thank you. Good luck.
Thank you, Your Honor.
We're off the record.
It's infuriating, but she did do exactly what she said she was going to do. She said, if you break this order, I'm going to have an evidentiary, or I'm going to have you in within 24 hours, and then we're going to have a show cause hearing or evidentiary hearing, and then you're going to go to jail. So she did it. She brought him in, and now she set that hearing. So we'll see what happens. Maybe.
Ma'am.
Person McDonald, D15-518-905D. The parties are present. Counsel
Packed
appears for the
courtroom.
record.
Russell Collins, bar number 11363 for plaintiff who was present in court.
Good afternoon, Your Honor. Mark Anderson, bar number 606, appearance for Attorney Kurt Smith on behalf of Michael McDonald, who's present.
All right, good morning. Is there anything administratively we can take care of? We've concluded the custody portion of the evidentiary hearing trial, and we'll move on to division of assets and debts. And everybody can have a seat. Can we stipulate to the universe of what those assets or debts are at the outset, or?
I think counsel and I talked, and we thought that we may just need to put a little evidence on.
Okay.
There's some contested facts. Yeah, okay. I would remind the court the last time we did request a closed hearing on this matter.
All right. And so we'll ask everyone to leave the courtroom except for statement except either party's immediate family under the rule. Counsel, what type of brief testimony do we anticipate just from each of the parties as to those things? Or is there any other witnesses regarding assets or debts?
I don't have any witnesses with respect to that.
Right. All right. So other than the parties themselves? All right. Can we start with the plaintiff, or does that make sense?
That'd be fine, Your Honor.
Yeah, why don't you come up to the stand? We'll swear you in again today.
I think so.
You solemnly swear the testimony you're about to give in this action to be the truth, the whole truth, and nothing but the truth, so help you God.
Or I don't think so. I thought so.
Go ahead, counsel.
Real quick, Candace, can you tell us what are the assets that you acquired during the marriage?
We purchased a home.
Let's start with the home.
Okay.
Where is the home located?
It's off of Jones and Cheyenne, 5813 Maynard Avenue.
Do you remember what the purchase price of the home was?
It was $84,000.
Do you know how much is currently owed on the home?
It's about $72,000.
Do you know what the home is worth now?
Yes, it's worth 120.
When you first got the
Sorry, 170.
70,000.
170.
When you bought the home, did you purchase it on a specialized loan?
We did have a down payment assistance program with that. They gave us $15,000 to help with closing costs.
Is there any money still owed with regard to that?
I believe so. I think it's 3,000 that's left. Like, so if we were to sell the property, we would owe that back as a loan, but there's only 3,000 left owed because we've almost occupied that house for 5 years. So after 5 years, we wouldn't have had to pay it back, but since we're at year 4 of owning the house, we would owe that 3,000 back.
And what is your intent with regard to the house?
I'd like to sell it.
Who is currently living in the home?
Michael.
And then would it just be your intention to just split the equity equally? Are there any personal assets inside the home?
Yes.
What are the assets inside the home?
All of the marital furniture and possessions.
Could you list what those possessions are?
There's a bed, there's a dining room table, there's a couch, TV, Xbox, both the kids' beds, so there's Malia's crib and then Mason's bed, and various computers. Yeah, that's all I can think of right now.
And what is your intention with the marital assets within the home?
I like to split them. I mean, when I left with nothing.
Other than the home, what's another marital asset that was purchased during the marriage?
Our car, our SUV.
And what is that SUV?
It's a 2011 Mazda CX-9.
Who currently has the SUV?
I do.
Has that been your primary vehicle?
Yes.
Okay. Do you remember how much you paid for the car?
21,000.
Do you know how much it's currently worth?
It's worth about 13.
Do you owe anything on that
Yes.
at this time? How much do you owe?
4,000.
And what is your intent with regard to the SUV?
I'd like to sell it.
And again, split the equity? Any other vehicles?
Yes, we purchased Michael's car.
And what is his car?
It's a 2001 Mercury Cougar.
Is there a mortgage on that?
No.
How much did you pay for it?
6,000.
Do you know how much it's currently worth? What would be your intention as to with the Mercury Cougar?
I mean, it's his car, you know, but if there's any equity to split it.
Do you currently have a retirement plan? Are you aware if Michael does?
Yes.
Do you know what that plan is?
It's a 401k.
It wasn't listed in this playlist.
I don't know his current situation, but when he was with the city of Las Vegas, he had 401k, and then before that, he had 401k. So pretty much since we've been married, he's had a 401k.
Do you know what the value of that 401k is?
It's probably about 30,000 at this point.
What would you like to do with the 401k?
Split it.
When you do you remember when you first separated from Michael?
Yes.
When was that?
Not this May, but the previous May.
And when you left in May, So that would be May of 2015.
Yes.
Did you take any cash with you when you left?
Did.
How much did you take?
2,000.
Where was that money located?
It was in a safe.
Were there any other items in the safe?
Yeah, like Social Security cards and marriage certificates and things like that.
Are there any other assets that we haven't discussed that need to be distributed by the court?
Yes, my wedding ring.
Do you know where your wedding ring is?
It's in Michael's possession.
Do you know what the value of your wedding ring is?
About $4,000.
And would you like that? What would you like to be done with the ring?
Just split the equity.
Are any of the assets that we talked about that are within the home, the beds, were those the children's beds?
Yeah, two of the beds are the kids' beds.
Okay. Any dressers?
Yes, we had.
Oh my god. Her dress has pockets, guys. Her hand's in her pocket right now. The bell's gonna get her, but she has pockets in her dress.
3 dressers.
And you mentioned you would just like to split that stuff up and just separate it equally?
Yeah.
Any other assets that we haven't discussed?
Well, it's not an asset, but I'd like my journals back. My personal writing.
Any of your personal property returned?
Yes.
Anything other than the journals?
Oh, there's my grandmother's lamp. It's a Tiffany's lamp.
Lamp?
A lamp, yeah.
Was that a gift to you from your grandmother?
Yes.
Anything else that we haven't discussed?
No?
Do you have any debt that you acquired as a result of the marriage?
Yes.
What debt have you acquired?
$11,000 in credit card debt.
What credit card is that?
Citibank credit card.
Any other
Because
cards?
he's nuts.
I have a JCPenney card and it has $1,000 on it.
Any other debts that you can think of?
Well, I mean, I paid for the daycare. Would that be considered a debt?
When were you paying for the daycare?
I paid for 2 months in.
Could object as far as what she paid. The question was debts, and we are here today to try property debts, not child expenses.
She's asking for arrears relative to an order I made. I'll allow the question. Go ahead.
So there was 2 months, August and September of last year, and then there's a current charge at the daycare. So I paid for those 2 months solely, and then I paid my portion of the daycare currently, and there's an outstanding balance still.
How much is the daycare?
At the time then, it was $1,189 a month. So that was 2 months of that, and then currently, because it was just for Mason and Malia for this week, her daycare will start next month, but that portion is $169. So I paid $169. There's a balance of $169.
And that's for this month?
Miguel, thank you.
Yes.
Thank you, Miguel.
Have you incurred any medical expenses for the children?
Yes.
What medical expenses have you incurred?
There's been an ER visit for Malia, there have been 3 quick care visits for Malia, and then I've paid all of their medical insurance premiums since we separated.
Do you know what that premium payment is?
Yes, it's $440 a month.
Does that include yourself?
Well, it's free for employees, but it's like a package deal. So then, like, an employee plus 2 kids would be $440. But yeah, I'm free because I'm a teacher.
And how long have you been making those payments?
Since we separated, May of 2015.
Do you recall how much the ER visit cost you?
Yes, it was $250, and I still haven't received any like follow-up bills from that. So, but it was $250 on the spot. That was my copay.
What about the 3 quick care visits? Do you remember how much you paid for those?
He made
One
photocopies
them
of
was
all
out
of them.
state, so it was $120, and then the other 2 were $50. That was my copay.
And has Michael contributed to any of those? Any other debts that you can think of?
Yes, it would be like for child support would be.
Okay, when we started, wasn't that a packed courtroom? And now there's only 2 people left. Is that because all the other ones were witnesses, so they had to leave, that are going to testify?
You getting any child support before December when the court ordered child support to be paid? Any other debts?
I had to
Just
go get
that,
coffee.
like, from December, when the 200 was ordered, he was supposed to report income because he was working and then didn't. So there's that portion of like what he should have been paying, and then I don't know. Is that considered a debt?
I think we've already addressed that in the proposed order, so I don't think that we need to go in that far.
Yeah. Other than that, I think that's the only other debt we have.
Okay. Yeah, I've got no further questions.
Counsel?
Yeah, starting kind of backwards from where you finished. Are you saying there's child support arrears owed?
Yes.
Have you completed a schedule of child support arrears for submission to this court to document what you claim is owed in arrears for child support?
I have not. I've just been waiting for instruction on that.
And you said there was some unreimbursed medical expenses from insurance.
Correct.
Did you submit those to Michael?
Yes.
When did you submit those?
As soon as they happen within 30 days.
And when did you do that?
Within the 30 days of whenever they were.
Month, year?
Well, this recent visit, I submitted it to him, to my attorney, and gave that information over to him.
My question was, did you submit it to Michael, not your attorney?
I did submit the other 3 to him, yes.
When did you do that?
I can't remember the exact date. There was one in December. There was one in March or April. There was one recently when we were in California, as well as the visit to the ER, which was recently.
Okay. And looking at your proposed exhibits, trial exhibits, are any of those submissions contained within the 28 exhibits that you submitted to the court for consideration for this trial?
I'm not sure.
Would you like to look?
No, thanks.
Why wouldn't you want to look to see?
I'm just
these
don't
are
understand
documents?
like why, like, you know.
Who asked her if she'd like to? She said she wouldn't like
She
to.
did answer the question. Now I'm asking why.
I mean,
Why
if they're
wouldn't
not
she
in
like
there,
to?
then they're not in there.
Does somebody
so I
really like to look at our exhibits, counsel? I don't know.
I'm not really sure, Your Honor. So, as far as you sit up here on the court testifying today, you're not aware of any documentation to support any claims for any of these medical bills other than your testimony.
Well, I've submitted them to Michael, and I've submitted them to my attorney, and I'm assuming that he's submitted them to. I mean, there's been
You're
also
asking
a lot
my
of
client to pay.
changeover in between, like, attorneys too. So maybe his old attorney had it. I don't know.
We're not comfortable with assuming that. We want to know if you've submitted that to the court.
I've submitted it to my attorney.
And that's all you can say.
Correct. Yes.
And if you were being asked to pay bills by Michael, you would want the bills to be submitted to the court, so the court knows what they are and sees documentation of them, correct?
I would be fine if they were submitted to my attorney.
All right, so if I told you Michael submitted to me a bill for $8,000 or $10,000 in money taken from the safe, you would be fine with that?
I'm sorry? I'm not following.
If I were to represent to you that Michael has submitted documentation to me concerning $10,000 being taken from the safe, you would be fine with that?
No, because that didn't happen. But if it was regarding my children and medical and it was my portion that I had to pay for, I would definitely take that and pay for my portion of it.
But you said when you left you took $2,000 from the safe.
I did.
How was that money denominated?
How does it nominate?
Denominated. What denominations of cash? I assume it was cash, correct?
It was cash, yeah. I don't remember. 20s, probably. There was some hundreds in there, probably, too.
What were the serial numbers?
And how did that money happen to end up in the safe?
We put it in there together, and there was quite a bit more that used to be in there, but wasn't when I took that money.
You were, in fact, saving up for a yard for the house, isn't that true?
No, I was saving up to leave him so I could escape.
And did you tell Michael you were taking cash from the safe?
No, but he had $7,000 in
Ma'am, if you could just answer my question. Did you tell him that you were taking money?
I did tell him, and he got angry and moved out. So
Well, you just, when I first asked you that question, you said no.
I'm sorry, I'm stressed
Can you answer?
out with these questions. Yes, I did tell him, and yes, he was angry, and then he moved out.
Was there a journal kept of the monies that were placed in the safe?
No.
A ledger? Can I approach the witness, see if I can refresh your memory?
I've done that. I've done that. I didn't put it where he could see it, though.
It's from back in 2010.
Can I approach the witness? Have you seen this document before?
I have not seen it.
Do you recognize the handwriting?
No, I don't.
So, you testify.
Just one second.
Do you recognize the second page?
Yes, I do recognize this portion. I don't recognize this portion, though.
Okay. What portion of the second page do you recognize?
My handwriting. That's my handwriting.
And what is the circumstances that you came to make this handwriting?
I have no idea.
Do you recall when you made it?
No.
Can you read into the record what you wrote here?
I'm really not comfortable reading it.
It's your handwriting, so
Give it to me, I'll look at it.
can you tell us the gist of what you were writing?
I suppose it was a letter just expressing my feelings towards my husband.
They need CJ there to read that letter into the record. Oh, that would be epic.
And what feelings do you recall expressing?
Those seem like positive feelings to me, but I don't know when it was written or the context.
Let me do my job, okay?
All right, so
And for the record, that portion of what you're trying to refresh her recollection with of that page seems to be a letter and not a ledger or accounting of money.
I will have him testify to it, Your Honor.
I just want to make sure the record was clear. I was under the impression by your questions that that was a ledger.
It may be my misunderstanding, Your Honor, but I'll have Mr. McDonald clear it up. Now, when you took the cash from the safe, did you count it up?
Not at the house, but yes, I did count it.
And so you didn't know how much you were taking out when you took out the cash?
No, I did not until I ran and put it somewhere safe.
And it just happened to be $2,000 even?
Yes, I mean, it may have been a little bit less than that. I don't remember, but it was somewhere around the ballpark of $2,000.
Okay, so you're changing your testimony now. Earlier you said it was $2,000, correct?
Yes.
And what did you do with that cash once you took it out?
I deposited it into my own bank account that I opened.
Do we have any bank records relating to that?
I do have them, yes.
We have them here today.
I'm not sure what you have and what you don't have.
Well, have you provided them to your attorney to submit to the court?
I have.
And so you would expect they would be part of your 28 exhibits to be submitted to the court? Would that be your expectation?
I'm not aware of what should be an exhibit.
Can I approach the witness, show her as an excerpt exhibit book placed before?
Do we have exhibit books? Exhibit books?
We don't have an extra exhibit book.
Can I approach her then?
Let's take a brief recess. We need them all back for today. Council approach. You can go off the record. All right, we're back on the record. Ma'am, why don't you come on back up? Council, go ahead.
May I proceed, Your Honor?
Please.
And my intent is to just basically cover matters raised and reserve the right to call her in.
Certainly.
All right, so you were telling us about your educational background. You have a bachelor's degree, you said? And where did you?
You have to answer out loud yes or no, just because
yes.
we're recording it. Thank you. Go ahead.
Where did you obtain that degree?
UNLV.
When did you graduate?
In 2008.
And what was your field of study?
Communication.
And when did you and Michael first meet?
I graduated August of 2008, so we must have met in 2008 or 2009.
How long did you date each other before you married?
9 months.
Now you testified in direct examination that at some point Michael told you that he's bipolar.
Correct.
When did he tell you that?
I believe he told me that when. Well, he told me that once we were engaged. Once we were engaged.
Well, your direct testimony is while you were dating.
Okay.
But still, you haven't told me when he told you that.
Like at what specific time or where?
Approximately. Best to be Christmas. It was cold. It was summer. We were on vacation. Anything that you remember about it?
I just remember it being a conversation at his house. I remember it being cold. I just remember him not giving me very many details about it.
Okay. Well, wouldn't you ask for details if somebody told you something like that?
Well, I guess the thing that I saw was that he seemed very normal, and my understanding of bipolar was depression and like periods of being hyper and manic, and so I never saw Michael be depressed. And so I didn't think, he said, oh, I don't take medication. It was a stressful period of my life. It was one time.
So this person that you're engaged to
Yes.
tells you that they're bipolar, and you're not concerned to ask for any further details.
Well, I did once I found out he was receiving SSI benefits. That's when I started being like, oh, there's more to this story than just the one time or what was going on at that point.
Well, how much later was that?
I would say we were married after a year and a half, so at that point, around 10 months of dating, I found out when we were planning our wedding, I found out he was receiving benefits.
Well, the only evidence that you can present to this court to support your claim that Michael's bipolar is your say-so. You have no records that back it up, do you?
No, I don't have records.
You've had plenty of time to obtain records in preparation for this case, haven't you?
I think it was an issue of not signing a HIPAA release form, is what I was told.
You have no records here today to support your claim, do you? And you have claimed that Michael committed domestic battery on you. That's your claim. We have no police record that would corroborate any of that, do we?
Unfortunately, no.
And you tried to explain that by saying and testifying earlier that Michael would not allow you to leave to call the police.
He wouldn't let me leave at all, and especially not to call the police.
And at some point you were able and free to call the police. At some point you left.
I mean, yes, after I threatened to run to a neighbor or scream bloody murder or,
And you didn't call the police at that point either, did you?
I did meet with a domestic violence advocate.
Then you can answer my questions. I didn't ask.
I'm sorry, can you ask
did not
me?
call the police?
Not then, no.
Not at any time. We don't have any records that show that you documented with the police any claim of being abused.
Yes, and I should have.
And we don't have any photographs of any marks or abrasions to your body that would support any claim of being domestically abused.
I agree, yes, I should have.
We don't have any witnesses that would be coming here to court today to say, I saw Michael strike.
I have witnesses here today.
I
who
saw
know-
it.
who know about the abuse.
I saw it.
Asking about and know about the abuse. Do you have anyone here that would say that they saw Michael strike you?
No, he never hit me.
Okay,
Either.
he never hit you. Okay. When is your contention that the first time that he was ever physically abusive to you? When did that first occur?
When Mason was 2 months old.
And that would have been what year and month approximately?
August or September of 2011.
Could you look at Exhibit H before you? It begins at date stamp, page 53. If you review pages 53 through 56. Can you tell the court what those are?
They are Facebook posts that I made.
Move for admission of Exhibit H, Your Honor.
Counsel, any objection? Be admitted.
Right, if we look at page 53, and actually I believe 54 has a more complete account. August 4, 2014, could you read what you wrote about Michael?
Watching Michael McDonald love on Malia yesterday at church made me a bit emotional. Growing up, I had a strained relationship with my dad. It brings me great comfort and joy to know that my children will never grow up wondering if their dad loves or cares for them. What a gift I have found in you, Michael.
What did you observe concerning Michael with regards to Malia at that time that led you to make that post?
It was the picture of him holding her. That's what I observed.
That's the one on page 53?
Correct.
And then above that, on August 9, 2014, you wrote, when a woman is loved well, she blossoms?
Yes.
And could you explain your comments there?
It was just a quote that I read in a book and thought it was nice.
Well, were you feeling well loved at that time?
Dude, shut up for a second. Let
So
him
you
work.
just picked a quote at random to post, not to express your feelings?
Yes. I actually posted that because
If you could go to page 55. October 22, 2013. What did you post?
happy birthday to the most caring, loving, hardworking daddy and husband.
And that was referring to who?
Oh, Michael.
What grade do you teach?
I teach 12th grade.
And what's your school?
Bonanza High School.
What's your schedule, work-wise?
It's changed this year, but our report time is 7:05, except for twice a week we have to report at 6:30, and then we're off at 2:15.
And you said that's changed?
Oh, just the 2 mornings that we had. That's extra this year, where we have to go in at 6:30 twice.
Who watches the children when you were going in at 6:30 or 7:05?
The daycare.
You know, as far as the daycare, this daycare that you were talking about actually had to add more staff because of the number of children they had there, didn't they?
I'm not aware of any ads and stuff.
Are you aware of them having any developmentally challenged children under their care?
They have 2 separate schools. On one side is the preschool, and on the other side they do have, it's an elementary program up through high school that work with children with special needs.
You mentioned at one point Michael, the children returned from a visit with Michael with a rash.
Mm-hmm.
Have the children ever gotten a rash while under your care?
A diaper rash. Malia's had a diaper rash on a few occasions.
And didn't the children get foot and mouth disease from daycare?
I'm not certain where they got it, but yeah, both of my children have had hand, foot, and mouth disease.
When did they have that?
Mason had it once when he was in, I don't know, maybe a year and a half, and then Malia had it again once this year as well.
And do you take any responsibility for them obtaining that?
I'm sorry?
Do you take any responsibility for them obtaining foot and hand?
Me? Like, me giving that to them? No.
Did anything you do cause them to contact that?
I mean, not that I'm aware. I mean, I'm a sanitary person, so. Thanks, Ray.
As far as daycare, do you consider
I
the fact that
lie
children can
a lot.
obtain illnesses and such from attending daycare?
Oh, sure, yeah, I know that happens.
So when
Kim,
your
I love
daughter
your
came
dog.
home with a rash
So pretty.
after a visit with her father, you said Michael couldn't tell you where it came from.
Correct.
And is there some reason he would have special knowledge of where a rash that occurs on a child comes from?
It was just alarming because it was from head to toe, and that he hadn't noticed that she was covered in a rash. That was more my concern. I guess less about where it came from and more about why he didn't get medical care for it.
And you weren't there during his time visiting with
No.
children, so you don't know whether he noticed or not, do you?
Oh, he told me he didn't notice she had a rash on a text message.
And do we have that text message here today?
It may be. I don't have it in front of me.
Are you as far as your health,
Fozzie's always here.
are you presently under the care of any physicians, psychiatrists, psychologists, counselors?
I have seen a counselor, yes.
And who are you under the care of?
Her name is Nancy Caldwell.
And she's a marriage and family therapist?
Correct.
How long have you been seeing her?
I began seeing her when we had couples counseling. She would do, her husband was seeing us as a couple first, and then when Michael and I separated.
My question was how long? I don't mean to be abrupt, but we have limited time.
So probably when we separated, which would be May of 2014.
And one of the reasons you've seen the counselors because you have difficulty managing stress.
Correct.
And you've also had problems with fatigue. Caldwell didn't assist you for treatment for fatigue? What problems do you have handling stress?
Just feeling like particularly the marital stress and then the stress of the divorce and the stalking and the constant text messaging and the never leaving me alone and showing up where I'm at and pretty much just coping with dealing with someone with a mental illness.
What about stress in your professional life?
I'm still taking it.
Don't you have stress?
Oh, yeah, I mean, there's stressors being a teacher, of course, yes.
I can imagine a 12th grade teacher might have.
Maybe so, yeah. You were asked about your consumption of alcohol by your counsel, and you would consider yourself a social drinker, correct?
No.
You haven't posted that you're a social drinker on your media post?
No.
Okay, if you could look at Exhibit L, beginning of date stamp 63. And you recognize this, do you not?
Yes.
And can you tell the court what this is?
This is my Match.com dating account.
And
Oh, creepy.
you posted that you're a social drinker on this account, have you not?
I did, but honestly, I don't know that I really focused on. There were only a few options, so I may have clicked on that. I don't know. I wasn't really thinking much about it.
There was a time when you went up to a wedding rehearsal.
Not that I know, but there are only a few options. So if you don't say you're a social drinker, then the only other option is I never drink. Never. So if she doesn't never drink, then she would click only socially.
rehearsal at Mount Charleston, correct?
Yes.
And that was, I imagine, like most wedding rehearsals, where alcohol was served?
No.
No alcohol to,
I mean, they have a bar there, but there was no alcohol served.
and you wrecked your car at that time, didn't you?
I did have an accident, yes. It was snowing.
Now, if you also use marijuana, correct?
Once.
When did you use marijuana?
When I was out of town at a wedding reception.
And when was that?
Maybe July of last year or the year before. I think it was July 2 years ago,
So that would be,
2014.
and it made you feel, as you noted in your journal, fucking fantastic, right?
I wrote that, yes, but
Well, you wrote that because it was true, right?
I was feeling a lot of different mixed emotions at that time.
Are you saying that this thing that made you feel so fantastic, you've only done once?
Yes, absolutely.
You and Michael separated in May, I think you said 2014, wasn't it 2015?
No,
You separated in May of 2014?
yes.
When did you file for divorce?
That following July.
That same month that you separated, whether it was 2014 or 2015, you went to Chicago. didn't you?
It wasn't the same month. No, we separated in May, and then July is when I took the trip.
And you were gone for approximately 5 days? How long were you gone for?
It was the weekend. Friday, Saturday, I returned home Sunday.
And when you left for Chicago, you left the children in the care of Michael McDonald, isn't it?
Yes.
So you had no concerns about going off to Chicago and leaving them
No, I had
with their father?
concerns. I had concerns. And looking
The
back,
concerns did not keep you from leaving the children with their father, correct? You would agree with that, wouldn't you?
I'm sorry, can you ask me again?
The concerns, whatever they were, did not keep you from leaving the children with their father.
I did leave, yes.
Have you ever used alcohol to the point of becoming intoxicated during the course of your marriage to Michael?
Not that I can recall.
You have previously been diagnosed with a condition called PMDD.
I have to stop now. I don't want to, but we've been going at it for a while. I know I started late, but we still got all of our time in and more. This is almost a 3-hour stream. But I was so into it. I didn't want to stop. I still don't want to stop. We can't do this all in one day. We can't. So just so you know, I am going to go in and cut out the beginning of the stream where the ball was fumbled really badly. I love this case. I'm enjoying this so much. So, tomorrow can't come quick enough for me. I am going to pop into OJ for about an hour. So we'll get a tiny taste of OJ today too. Love to see you there, but if not, I will see you again real soon, guys. Nope, no Georgia courts still. So yeah, I'm gonna do OJ. No, Debbie, don't. I mean, the beginning. I first I played the criminal case, and it was wrong. It was everything was bad today. And by the way, replay crew, we have a chat in Discord just for replay crew. So I'll see you all again real soon. Thank you so much for coming out with me. I really appreciate it. Bye, guys.
Got these she lights the way. Her eyes near a sky so blue. In her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted sharp, in a way there's no alarm. Streaming tales late into the night, her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh